panel of presenters. As I say, we're going to record the webinar in its entirety, so that's the presentations and the Q&A afterwards. If you'd like to ask questions, if questions come to you as we're presenting, please feel free to pop them in the chat. Otherwise, please obviously feel free to unmute yourselves when we move on to the Q&A. So if I can just ask Ellie to put up the slides. Thanks.
There we go. Just give me a shout, Mary. Does that look all right?
Yep, that looks great. Thanks, Ellie. So the format today is a sort of panel discussion or webinar with focus particularly on the Casa Regina case, but also thinking about EU competition policy from a national context as well, and as well as some of the background to get to where we are now, so to speak. Next slide, please, Ellie. Just to introduce today's panel, we have Professor Johan van der Honden, Radboud University Nijmegen, whose expertise in the area of EU law and EU competition law, including in the healthcare context, is obviously very well known. Very pleased to welcome Johan today. We have Dr. Bruno Nikolic from Ljubljana, whose research interests focus on EU law, health systems, human rights and migration. So Johan and Bruno will be taking a sort of deep dive into the Casa Regina judgment in due course. We also are very pleased to welcome Dr. Mark Viggers, who's partner at Loyens Love in Amsterdam, as well as holding academic posts, whose focus has been on EU competition and national healthcare related law. And myself, Dr. Mary Guy, my research has focused on comparative approaches to competition policy in healthcare in the Netherlands and England, and this within the context of EU competition policy. So unfortunately, Dr. Andrew Morton from Leeds is unable to join us. So he would have been providing a sort of political science perspective, as it were, on EU competition policy in healthcare. So we hope he will be able to join us another time. So just that's an overview of our panel for today. What we're going to do is I'm going to start by giving a bit of an introduction to EU competition policy in healthcare before passing over to Johan, Bruno, then Mark, before concluding and opening the floor to questions. So by way of introduction, how it started, so to speak, EU competition policy, the connection between EU competition policy and healthcare sort of started to become clearer roughly around the late 20th century, moving into the 21st century. We start to see more of an interest shown at EU level in national healthcare systems with regard to competition policy via a range of case law. So obviously thinking of a sort of more economic aspect of EU law with a more social aspect as well. So obviously this can speak to wider narratives of constitutional asymmetry, rise of the regulatory state, the expansion of EU influence in healthcare. If we think of Scott Greer's three faces approach, here we're focusing more on sort of internal market face, shift away from the idea of the EU just as having a sort of public interest, public health interest, to one where the focus is on healthcare system organisation. Greer's also described this as a sort of uninvited Europeanisation. I think when we've seen references to Europeanisation of national healthcare systems, there's been sometimes a linking of this perhaps more with particularly the free movement rules, but something that's been traced across competition related judgments as well. So, and the free movement case law has of course shaped some of the earlier writing on EU competition policy in healthcare. But what we also start to see as a sort of interaction is the interaction between the EU level and the member state level. That's for the next slide, please, Ellie. And particularly the sort of circular relationship emerging here. So we see from countries which have actively engaged with competition reform, such as the Netherlands, for example, offering some lessons. And we start to see how the two levels can interact. So if we take Article 168.7 as the member state competence with regard to healthcare system organisation, health policy and so forth, on the one hand, it might seem, you might be forgiven for thinking that this means that member states have a certain degree of freedom to experiment with competition reforms in healthcare. But the logic would seem to suggest that such a decision can only go so far, and such a decision has the consequences of entailing applicability of EU competition law. So thinking in terms of the antitrust rules and the state aid rules in particular. What we also see in this equation is the distinction between healthcare system types. So on the one hand, being suggested that there's simply greater scope for competition in an insurance-based system than there is in a taxation-funded system. But in the judgments, we obviously see a more sort of nuanced approach with other permutations coming to light. So although there may be greater amenability to competition reforms in some healthcare systems than others, the expansion of private sector delivery of healthcare services and perhaps to a lesser extent, the operation of public healthcare providers treating private patients are features that are coming through more and more. So taken together, these raise questions not only about the applicability of EU competition law and the extent of applicability, and I'm using the word applicability because application entails a wider set of considerations as well. Sort of even the theoretical aspect of applicability. Is it possible to have one size fitting all, so to speak, in terms of how and when competition law applies? And can we sort of generalise across countries, or does it, from a sort of wider EU perspective, is it the case that if there's competition with regard to a provision of a particular healthcare service in one country, does it necessarily follow that this should also be the case in others as well? Next slide, please, Ellie. So I just wanted to give a very brief sort of 101 of EU competition policy in the healthcare context, with the benefit of anyone who's perhaps less familiar with this. It's obviously, what we want to do with these discussions is broaden the group of people who engage with this. Got a very esteemed panel of competition lawyers here, but this is a discussion which needs to be had beyond the confines of competition law circles. So in essence, when we're talking about EU competition policy, our focus here is on Articles 101, 102 and 107, the prohibitions on anti-competitive agreements, abuse of dominance and state aid. And within those prohibitions, there's a requirement, or the implication, that the anti-competitive behaviour may affect trade between member states. In terms of analysing these prohibitions, however, we don't always get as far as thinking about the effect on trade between member states. In some ways, some of the discussions tend to sort of buffer around this idea of is competition law even applicable? Is there an undertaking? We have a functional definition for undertaking, that is to say, an economic activity as defined in the Höfner case, defined further as an economic activity which consists in offering goods and services on a market. And we can see from the diagram that whether or not there's an undertaking determines the scope of applicability of competition law. There's a further refinement in this approach is the use made of the services of general economic interest exception. This engages also again, the interaction between the EU level and the member state level, given that it's a matter for member states to sort of designate services of general economic interest. And what this framework really gives us is a sort of very broad framework whereby healthcare providers are typically thought to be subject to EU competition law, but healthcare purchasers or managing bodies may generally not be. And this, in a sense, reflects this functional definition. If there's an economic activity which consists in offering, that indicates the sort of provision, would seem to suggest the provision side rather than the purchasing side. Next slide, please, Ellie. So this general framework, so we have the reference to undertaking in the treaty, but we're looking to the case law for the sort of definition of this and the elaboration of this. And I'm going to suggest tentatively that we can start to think in terms of 2 generations of case law. And that's less to indicate that there's been a kind of seismic change in approach taken at EU level, and more what we're seeing over time is that more and more healthcare systems are engaging with what would typically be regarded as some form of marketisation reform, so public-private interactions, expanded use of private sector delivery of healthcare services, and so forth. So in some of the earlier cases, such as ambulance gluttony, we have the starting point that competition law applies to healthcare providers, but not where there's a service of general economic interest. And the distinction in that case was between standard patient transport being subject to competition law and emergency ambulance services not being classified as an SGEI. We see with our Bundesverband a case about German sickness funds that these were not considered undertakings in EU competition law, and this went on to have implications for some of the reforms introduced in the Netherlands. We see with Fenin, case involving the Spanish national healthcare system, a distinction emerging, suggesting we look at effectively upstream and downstream activities. So not just the activity of purchasing, but the ultimate aim as well. So where healthcare services are being purchased for a solidarity aim, this may not be subject to competition law. 2010 onwards, we have cases such as the H case involving hospitals in the Brussels region. So very sort of different considerations coming into play within the Belgian healthcare system. More recently, the Dôvera judgment relating to Slovak health insurance, and our focus today on Casa Regina about payment to Italian hospitals. So what comes from this range of cases is obviously the diversity of member state healthcare systems, but also a sense of characteristics as well. Some of the same points, or in very general terms, some of the same points keep sort of emerging. One of which is how much competition or solidarity is there within a particular healthcare system. And the implication here would seem to be that if there's any sense of competition, if there's any sense of profitability, competition law should apply. I'm going to suggest that perhaps the approach taken by the courts is better understood as starting from the other perspective. The focus is on how much solidarity is in a system, such that competition becomes seen as a means to an end rather than an end in itself, as it were. So we're not necessarily thinking in terms of healthcare systems as being based, suddenly shifting from a basis on solidarity to a basis on competition. There's still an ongoing commitment to solidarity, and competition is the means by which some member states want to operationalise that ongoing commitment. It's been suggested we've seen inconsistent approaches across the institutions at EU level. CJEU has taken a fairly consistent approach. Dôvera effectively reinforced the findings which had emerged from cases such as our Bundesverband and Fenin. But we also get the sense of, the more it's necessary to look at the individual member state healthcare systems, the question of whether or not it's possible to transfer some of the insights, both in terms of member states understanding and interpreting EU law, but also at a sort of EU level as well, to see where there may be some common points. So on that note, I'm going to introduce our first panelists. So firstly, Professor Johan van der Honden, and then Dr. Bruno Nikolic, who in 2 ways are taking a deep dive into the Casa Regina Apostolorum judgment. So over to Johan, thank you.
Thank you very much, Mary. Very interesting. Thank you for introducing me, and also for setting the scene of this interesting workshop. Yes, I would like to discuss the Casa Regina Apostolorum case, and what are the consequences for the national healthcare system, and what is the approach taken by the General Court. It's an interesting case, and probably could go to the next slide. It's an interesting case because, again, and another slide, yeah, Because again, the concept of undertaking is addressed. I would like to start with shortly reminding you of the concept of undertaking and how it plays out in healthcare law. Then I would like to indeed to discuss the case, Casa Regina Apostolorum, and also how the Italian healthcare system was set up, and also what the Commission has said about this system. Then I would like to move on to, let's say, the core part of my presentation, which is the ruling of the General Court. And then I would like to share some findings with you. I would like to go to the next slide. Well, the concept of undertaking is well known. It's a kind of mantra, to be honest. Every case starts like this. Entities engaged in economic activities and undertakings. And as Mary also rightly set out in her presentation, indeed, the offering of goods and services on the market is regarded as an economic activities. But how is this applied in the healthcare sector? Well, interesting to know that it's apparent from the case of the Court of Justice so far that a distinction should be made between bodies managing a healthcare system, like insurance companies on the one hand, and healthcare providers like hospitals on the other hand. And yeah, and when it comes to managing bodies, I think that the court examines with great care the design, the setup of a particular system. And the core question, as already was said by Mary, is, well, is this system predominantly based on solidarity? And if this is the case, if solidarity is indeed decisive, then the managing body is not an undertaking. And if there is a considerable mix of competition and solidarity, indeed the competition rules apply and the managing body is regarded as an undertaking. SGEI is one of the examples of that, because the court decided at the end that this was a mix of solidarity and competition, and therefore competition law applied. And our car case, the German case, was the other way around. The German sickness funds were not regarded as an undertaking. When it comes to healthcare providers, the approach to date is way more different from what the court has done in the cases concerning managing bodies. Here, I would say the approach is straightforward, probably you may even say simple, because they say, well, healthcare providers provide services for remuneration, for economic consideration, and for that reason, they are engaged in economic activities. But we should note, and it was as far as was my understanding till the Regina Apostolorum case was handed down, this was just a matter of the way the court dealt with it. But it's important to note now that the cases the court had to deal with were cases situated in member states having a social insurance system, so a system which is based on sickness funds and on private health insurance companies. So it means that the healthcare providers are paid for, the costs are covered by a sickness fund or a private insurance company. And this turns out to be of great importance, as we will see in the Casa Regina Apostolorum case. I would like now to move on to the next slide. This is the case Casa Regina Apostolorum. What were the facts in this case? Well, we had a private hospital which was run by a religious community, if I understood it correctly. And this private hospital operated in the Italian system of healthcare as an SSN. And the public hospitals got a lot of funding from the regional authorities, from the public authorities in Italy. And this private hospital was of the view, well, this public funding amounts to state aid. The financing of services of the hospitals, and I think mainly the public hospitals, was based on predefined rates. But the private hospitals claimed, well, they have a lot of deficits and they are covered, the deficits, so they got funding to deal with those deficits, but the funding is not based on the real cost, on the actual costs of the services rendered by the public hospitals. And for that reason, it's illegal state aid. So there was a complaint, And this complaint was sent by the private hospital Casa Regina Apostolorum to the Commission. And what did the Commission say? So could we go to the next slide, please? What did the Commission say? Well, the Commission started with explaining how the Italian healthcare system was set up. So it's very interesting, and it's clear from the explanation of the Commission that this was a National Health Service-based system. All citizens are entitled to the same level of healthcare, so it depends on the citizenship. If they reside in Italy, they're entitled to healthcare free of charge. So the hospitals, but also other healthcare providers, of course, provide those services free of charge. And what's interesting is that the hospitals and other healthcare providers are directly funded by the state, from social security contributions. And this was very important in the view of the Commission, because the Commission said, well, we have two types of healthcare systems in Europe. Systems where insurance is very important, health insurance, and there healthcare providers are remunerated, paid for by the insurance companies or sickness funds. And we have a national health service type of healthcare system, and then the funding comes directly from the state. And please go to the next slide. The thing is that the Commission says, well, that's important. And then it starts to, after having explained that we have this distinction in Europe, it started to, of course, to discuss the Italian case. And it was of the view that solidarity was really predominant in the Italian healthcare system. Because of the financing by the state and the provision of healthcare free of charge. And also at the heart of the system was universal coverage. Everybody has access to public healthcare. Yeah, therefore, because it was an NHS kind of system, the Commission was of the view that solidarity was predominant and universal coverage was an important thing. Those were the decisive elements in the reasoning of the Commission, which at the end of the day made the Commission decide that competition law did not apply because the public hospitals were not engaged in economic activity. So that's very striking because this derogates from the set of case law of the court. Because now I would say kind of for the first time, you could have kind of discussion about Fennon, but probably we could have that later on. But you could say in comparison with other cases, which are also outlined by Mary, like Pavlov, like Ambulance Gluckner, the Iris Hospital case in Belgium. Here the courts were pretty clear. Healthcare providers are undertakings. This is different because this is a NHS type of system. Solidarity is predominant, and the public healthcare providers are not engaged in economic activities. So the question was, well, what did the General Court say? Probably you could go to the next slide, please. What's very interesting is that what the General Court said is that it copied and pasted the line of reason of the Commission. You could point to some differences, but I would say mainly the General Court has had the same view as the Commission. So that's quite interesting. And also the General Court started from scrutinizing the role of solidarity in the Italian system, and therefore it made a reference to the Slovak insurance company system, so the Dôvera case, which is a bit striking because Dôvera was about the question whether a managing body, a private insurance company, was an undertaking. Now we're talking about a healthcare provider. But anyway, this was the start of the line of reasoning for the General Court. And like the Commission, the General Court assigned great value to the arguments of solidarity and universal coverage. It was also indeed underlined that public funding came directly from a state body, came directly from social contributions, and this was the source of funding for public hospitals. They could provide services free of charge, and therefore it was non-economic. The activities were of non-economic nature. And again, the importance of universal coverage was emphasized. However, there were some reforms introduced, and those reforms in the Italian system, in the SSN system of Italy, and those reforms were also addressed by the General Court. So please go to the next slide. The reforms, there was some introduction introduced by the Italians, but the General Court was of the view that this introduction of competition did not change the real nature of the system, because the funding still goes directly from the state to public hospitals. And as we know from the case like Dôvera, but also AOK, this German sickness fund case, we know that let's say the introduction of some competition does not change the nature of a particular healthcare activity, the nature of the healthcare operator, because it only leads to some kind of sound efficiency in the view of the General Court, and therefore competition still does not apply. In my view, this is strange, because in my view, I'm a competition law specialist, and I think competition law is, amongst others, about efficiency. So if you introduce a system geared towards efficiency, you should apply competition law. But the union courts have a different view on this, and they say, well, just a small amount of competition only introduced to give a boost to efficiency will not do. So that's we have to live with that. Also, the freedom of choice of patients did not call into question the universal coverage. Some patients with a lot of money could afford, let's say, private healthcare providers, could afford to go to a private healthcare provider and get treated there. But the court said, well, that's not a problem, because the other persons who are less well-to-do could still go to a public hospital, to other public healthcare provider. And it means that universal coverage is still one of the main elements of this system. And also at the end, very shortly, the General Court started this very practice of, we also had this in the Netherlands in the past, of physicians operating in a commercial way outside office hours. So they are employed by a public office, but in the weekends or at night, they operate persons on their own costs. So they make a lot of extra money. So this, let's say, extra activities are of an economic nature, but this does not change the nature of the NHS system, of the solidarity system of the Italian healthcare system, because these, let's say, commercial activities of the physicians are carried out outside the framework, outside the context of the Italian system, a kind of market which exists next to it, and thus it has no any bearing on the conclusions with regard to the concept of undertaking. So also that argument was rejected by the General Court. So what does this mean? So probably we could go to the next slide. What could we say in terms of conclusions about this case? Well, probably go back to the first, this one, find this one, I'm sorry. Of course, the first thing we have to note is that the Court of Justice has to confirm this case, but suppose the court will do that, so this will be settled case law. What does it mean? Well, in my view, it means that member states having a system based on social insurance has less room for maneuver than member states having an NHS system. Because it's apparent from Pavlov, for Ambulance Glagner, that hospitals are remunerated by insurance companies, by sickness funds, and for that reason, their activity is of an economic nature, because they got money, not directly from the state, but from a sickness fund or insurance company, and for that reason, their activity is of economic nature. That will not change. So it means that if you would like to change your system, you review your system due to some lessons learned during the COVID pandemic, you still have to observe the competition rules, including the state aid rules, which are very important, of course, in healthcare. This is different for National Healthcare Service, because if you are able to base your system on a solidarity-driven setup, then you may escape from the competition rules, including the state aid rules. So it depends on, let's say, the role of solidarity. And I would say a NHS-like type of system like Italy or Spain, you could say, well, of course, solidarity is at the heart of this system. So I would say that the majority of the public healthcare providers will then be immune from the competition rules, including state aid. So that's an interesting finding, I would say. And what does it mean? Probably we could go to the next slide. I made a little table. I was very happy I was managed to do so. It took me quite some time, believe it or not, but I was happy to have this table. And you will see I made a table. Well, what about the NHS system and social insurance system? When it comes to the concept of undertaking, well, a managing body in the NHS system, is this a undertaking? It depends on the design. So what role for solidarity? Same is true for social insurance companies. Are social insurance companies like sickness funds or the private health insurance companies in Holland or elsewhere, are those entities undertakings? Well, depends on the design. You have seen from the Slovak case that even private health insurance companies may escape from competition. This is different for healthcare providers. At the NHS, again, it depends on the design, whether a particular care provider is an undertaking. But this is different in the social insurance system. As a rule, healthcare providers are undertakings. So I think it's apparent from this little table that it definitely matters whether a member state has a social insurance system or an NHS system. And I would like to go to the last slide to finish up my presentation. My question is, well, is the ruling in Casa Regina Apostolorum now a coherent approach? Because is this approach kind of neutral to the system of a particular member state? I don't think so. So I have some troubles with it. And therefore, you could consider whether we should adopt a different approach to the concept of undertaking when it comes to healthcare providers. So in some publications, also together with Mary, we made a proposal that we should focus on the activity itself, on the service itself. If the service itself cannot be provided on the market, it's mainly depending on financing by the state, you could say there's no market for such a service. Such a service cannot be provided on the marketplace. It doesn't make sense to apply the competition rules to such services, including the state aid rules, and therefore it should fall outside the scope of competition law. But however, on the other side, if a particular service can be provided on the market, there is a marketplace for it, it makes sense to subject it to the market rules, and the market rules are the competition rules and the state aid rules. So this was my presentation, and thank you very much for your attention.
Okay, thank you very much, Johan. So just following on from that, Bruno's perspective on the Casa Regina case, please. Thank you.
Thank you very much. Mary and Johan nicely presented overview of competition policy and the Casa Regina judgment, as well as some potential implications of this judgment for national healthcare systems. You made my job a lot easier now because I can focus only on those things that I find the most irritating and my biggest concerns. So my presentation will be focused on some of my main concerns raised by this judgment, an approach taken by Commission and General Court. I think that we are pretty much on the same page with Johan, actually. Please excuse me, I have some medical issues and hopefully this will not interfere too much with my presentation. I would like to highlight 3 different concerns raised by the judgment, in the Casa Regina case. 2 of them are technical in nature and 1 more general. These concerns are not merely a consequence of this judgment, but rather evolution of the term undertaking based on the approach of the Commission and the Court of Justice, which we already heard from Mary as well as from Johan. Basically, I will not go through the case Casa Regina, just some important facts for my concerns, which you can see on this slide. Basically, that the Italian SSN, which Johan nicely defined, is not economic in nature. That means that all providers of health provisions in this system are also not undertakings, and as such are not within the scope of the competition law and state aid rules. I already highlighted several potential errors of law regarding the approach and interpretation by the Commission, and talked about it last year. I think actually it was also the first session in 2021, which is why I will not repeat myself today. I will jump straight away into concerns, and I would like to highlight today. But for those who are not familiar with my presentation from last year, here you can find the article where I am broadly talking about this topic. So if we can go to the next slide, and my first concern, please. My first concern is with referencing social health insurance cases when assessing the nature of health service providers. This is something that I can sense also Johan is struggling a bit with. Here I am quoting paragraph 154 from the case Casa Regina. It is a copy of the paragraph in the Dôvera case, with the exception of the part which I bolded, including a branch of healthcare such as under the SSN. Basically, the General Court just broadened the definition from the Dôvera case, which related to the social health insurance provider, to the public health and private health providers with accreditation in the Italian system. What I'm concerned here is that the case law regarding the assessment of the nature of health service providers or provisions, like already Johan mentioned, existed before the case at hand. For instance, Ambulance Glockner, Paolo, Fenin, and Iris cases, which I think that weren't referenced in this case at all. Two at least kinds of approaches exist when assessing the nature of social services. Approaches taking in assessment of the nature of health service providers. Here we also have two approaches which raise additional concern, but I will talk about this concern a bit later. And on the other hand, approach taken in assessment of the nature of social insurance providers. In Casa Regina, we have the assessment of the nature of health service providers, and the Commission and General Court applied approach taken in assessment of the nature of social insurance providers, referencing mainly Dôvera case. Why are institutions, Commission, I'm thinking about Commission and the General Court, not following a theory of severability as defined by Hatsopoulos and address social health insurance activity separately from service providers? A.J. Maduro stated that concern already in Fenin case when he argued that financing of health services and on other side provision of health services should be assessed separately. On one side, we have social health insurance, basically financing of health services, and on the other, we have public and private health service providers, which are involved in a different activity, subject to different principles, even though, of course, we can draw some parallels between both of them. Let me now move to my second concern, which is what I already referred to. Different versions of the functional approach, which Mary nicely defined, which lies at heart when assessing the nature of health service provision. On one side, we have pure functional approach, relying on two constituent elements defining the economic nature of an activity, which Johan already mentioned. These are the cases such as Paolo, Ambulance Glockner, Iris. And on other side, we have moderate functional approach, as Gallo is referring to. As in the cases like Fenin, I would also like to stress out the ICIMU decision, not directly concerned with the healthcare sector, but plays an important basis for Lazio case and now the Casa Regina judgment. There are no criteria or guiding principles when to use which of these two approaches, and as a result, when activity at hand is economic, or non-economic in nature. I have also already pointed this out in my article and tried to find a methodology to resolve this issue. Which brings me to my third and final concern. Third concern is not linked to the technical aspect of this case, even though I did not exhaust all my technical concerns, but we can talk about this later in our discussion, but with more general consideration, which could be framed in one question, and I will be deliberately provocative here. Why would we exclude, in general, health services provided in public health care system from the application of competition law and state aid rules? And it's not a rhetorical question. Let me play a little bit with it. I acknowledge, as AG Maduro said, that this is dangerous territory because there must be a balance between the need to protect on one side undistorted competition on the common market and respect the powers of member states on the other side. And Mary nicely portrayed this interplay with her, I think, second or third slide. It sounds to me like sailing between the Scylla and Charybdis. Member states mainly understand application of competition law and state aid rules as limitation of their powers, but is this limitation bad if your end goal is good, I wonder? Let me give you an example about what I would like to say. A few years ago, Slovenian government subsidized public hospitals. By the way, all hospitals are in public ownership, although it is worth noting that private providers, with concession of course, provide some of the same health services as public hospitals do. Subsidization was in amount of almost 200 million euros according to some estimations. No outmark or any other criteria regarding fair compensation, we can draw a parallel here with the Casa Regina case, was applied when which raised concerns not only in the relationship between public and private providers of healthcare, but also within public providers. Director of one hospital called me at the time, and she was concerned that other hospitals will get more money because they have better connection with leading political powers. And also she said they will get more money because they ran much more imprudent job than we did. So there was substantial lack of objective criteria for division of money, subsidies, in her opinion. Ministry for Health made research about reasons for losses, which did not reveal much. Poor efficiency and efficacy were not among reasons responsible for losses. There were only some reasons of objective nature, which was nothing on the shoulders of management of hospitals or on the owners of hospitals, which is ministry, of course. Ministry, this implies on strong arbitrariness, which strongly undermines effectiveness, efficiency, and sound management of public health providers, the same principles that were referred to by the Commission and General Court when they argumented why the introduction of competition elements is welcome to the non-economic activities. One could say that this was not their fault, I mean hospitals' fault, but is this true, I ask myself. Legal framework for managing public health providers is one of the oldest pieces of legislation in Slovenia, dated back to 1992, just after we declared independence from Yugoslavia, and it hasn't changed since then. This law severely undermines the introduction of all corporate governance principles into the management of public providers. There are no signs that this law is about to change, even though our hospitals are constantly running into financial difficulties and we need to bail them out every now and then. If I open the curtain a little bit more and present some data, the situation will be much clearer. Independent journalist investigation revealed that public hospitals are paying for some medical equipment 70% more than, for instance, Sweden, which has substantially higher GDP per capita than Slovenia. And it is not just the case with Sweden. It refers to almost all richer countries in Europe, such as Finland, Germany, Austria, etc. We could name many more circumstantial evidence, such as some same payment for provision of health service given to private providers and public providers by health budget, whereby public providers are often faced with financial difficulties, while private providers are running lucrative businesses. The system is clearly in deadlock, and who can help it? Therefore, I ask myself, isn't this example a reason why we have EU competition and state aid rules? And the role of the Commission is to make sure that this kind of distortion of the market is evaded or eliminated. Application of competition and state aid rules does not necessarily mean that we are moving towards the liberal market-oriented health system. It may as well save socially embedded health systems, such as Slovenian, from transforming into liberal market-oriented systems. And the main reason for that is the service of general economic interest exemption in Article 106, paragraph 2, which could serve as a tool, as Galo said, and also Mary at the beginning. And I must agree with both of them, which could be understood as defining competition not as an end, but rather as an instrumental objective for the pursuit of other goals, such as economic and social development and an improvement of standard of living. With the use of this tool, which means that at first, of course, we must define health service providers as undertakings, they would have to pay much larger attention to efficiency and efficacy. This would strengthen them and at the same time prevent increase in private health providers, which inevitably leads towards more liberal market-oriented system. Because we didn't introduce private providers into the public system as an element of competition. We introduced them because public providers could not achieve the supply the same as we had the demand. That's why we opened our system to the private providers. And currently we have 1,446 private providers within publicly financed health system and only 201 public providers within this system. And if we will not strengthen public providers, but clearly the country is not able to do that, then private providers with concession will slowly rate public providers under, of course, the presumption that we will not give additional state aid to private providers without any criteria as to their efficient and so. So to conclude, I'm afraid, and if you can go to the last slide, I'm afraid that I opened more doors than closed them. I think this is the same as with the Casa Regina case. So I hope that you will help me close some of them, and I look forward to the debate and your constructive criticism towards my views. Thank you very much.
Okay, thank you very much, Bruno. So we're just going to move on now to Mark's presentation of the Dutch perspective, and then for wrapping up with some concluding remarks. So over to Mark. Thank you very much.
Yeah, thank you very much. It was nice to see, Bruno, although you feel a bit sick, that you're still so passionate. It was good to hear, and I think you will like what I have to say in respect of the Dutch perspective as well, because we didn't know each other's speeches or keynotes, but there's a red line in it, so to say. And Mary, thank you very much for inviting me. It's a great honor to be, as a lawyer, be amongst your midst. Yeah, I prepared a slide. Johan, don't be afraid. I did this myself as well. It took me probably just as long as it took yours to finish your slide or the small presentation, the graphic that you made. So this is the overview. Like normally it would jump in. This is the PDF version. So yeah, it basically sums up, because what we're doing here today is like we have the two cases that we're discussing, the Regina case and the Dôvera case, and basically what immediately comes up is the question: how does this apply in the different member states? What does it mean for me? What does it mean for my jurisdiction? And how does this case interplays? And does it bring changes? Like you can alter your structure, as Johan mentioned, but of course you can also look at it more from a more defensive position. Does it already change? Does this ruling change the view on my system or not? Well, as Mary said, like it's of a tremendous importance whether or not you qualify as an undertaking, because if you qualify as an undertaking, competition law is in principle applicable. So then, of course, as discussed, state aid cannot be given, price agreements cannot be made. But on the other hand, if you do not qualify as an undertaking, you can give state aid, and that's also like what Bruno is saying. Like it basically interplays with the market principles, and then of course you will not have the efficiencies. But what I will do is I will look at the Dutch perspective. So what I try to do is make it practical, because like as Johan already mentioned, like you need to look at the systems, you need to look at the characteristics, and then basically see whether or not you are an undertaking or not. And what I've done here in the slide, I basically listed the decision of the European Commission in the Dôvera case, because I'm focusing on the Dôvera case. I'm not focusing on the Regina case, because the Dôvera case, from a Dutch perspective, is much more interesting than the Regina case. As Jan already clearly said, basically, we do not think that the Dutch system is much similar to the Italian system. I will highlight some differences in a minute, but just quickly skip through it, because like I think the Dôvera case from a Dutch perspective is more interesting. What we've done in the slide is basically I show the 4 criteria that's being looked at by the European Commission. You see them in the blue. So the first question is there a social objective? That's basically only being glanced at. It's not a really careful assessment. Then you're basically going to look at this, the principle of solidarity. That's where the proper assessment comes into place. As Johan said, there you see more criteria. Then the profit making is a criteria, and which is interesting is, of course, in the Dôvera case, profit making was allowed, but still it was ruled that did not qualify as an undertaking, and you need to have the state supervision. So basically what I've done, I've looked at all the decisions. So first from the Commission, then the General Court, the European Court of Justice, then the systems, so that you can see whether they deviate, the Netherlands and the Slovak system, and then you have the basically the Dutch system. So this is more or less the background. And if you look at the 2 blue lines between 2 and 3, that's on the basis where the General Court said, well, we believe, because like in the Dôvera case, the General Court was overruled by the European Court of Justice, and basically on the blue line, so the competition for value for money and the profit making, altered the nature of the scheme in the mind of the General Court to economic of nature, and then qualifying as an undertaking, and therefore competition law being applicable, and therefore state aid rules are also applicable. So, but then it was overruled by the by the Court of Justice, and the Court of Justice said, well, okay, I can see that, but you need to look at it holistically. You need to look at the overall assessment. And in the overall assessment, basically what is important is the total nature. So how does it interplay? Is the solidarity that much that basically it's only the competitive elements only are there for the proper functioning of the scheme? That's what's in the top of the slide. And that's basically why they said, well, it doesn't alter the nature of the scheme. It's just a secondary nature. So that's a little bit like the background there. But like in the Netherlands, and before I'm gonna spoil all the fun and tell you my view. In the Netherlands, competition law has always been applicable to both hospitals as healthcare insurers. So since the introduction of our new healthcare system, this has been the case. So this has been the case in cartel decisions. We have many merger control decisions, but also dealing with the corona pandemic in the Netherlands, hospitals and insurers made agreements, which has been assessed by the Dutch Competition Authority. So if the Dôvera case would alter and the Regina case would alter that view, so basically competition law being applicable to Dutch healthcare insurers and hospitals, that would of course be a major shock to the Netherlands. So, but what I also try to do is because if I only talk about the Netherlands, I'm well aware that maybe only Johan and me are Dutch. So this also gives more an outline of how you could make such an assessment. And maybe that's because I'm a lawyer. I always want to make it practical. So you always start to look, what does it mean for me? How does this interplay for me? And I think that this assessment you can also do in different jurisdictions where the outcome might be different. So therefore, I think it's interesting to see. But first, maybe to go briefly to the Regina case. So there, of course, it was ruled that, as Johan also showed, that the system and the hospitals there do not qualify as undertakings. You can have many intelligent comments on that. But what I'll do is just quickly look at the Dutch system, and there you see some major differences popping up. The Dutch hospitals are not state-owned, and unlike in Italy, the Dutch hospitals actually have actual competition between another. They compete for the contract with the healthcare insurers, but they also compete for the favor of the patient. So that's of course a major difference. Also, the basic healthcare is provided both by the hospitals as by private clinics. And unlike in Italy, the patients of private clinics do not always need to pay themselves for the treatments provided by the private clinics, as long as the private clinics have a contract with the relevant insurer. And on the other hand, like also what was one of the main principles in the Regina case is that there's a universal right. In the Netherlands, there's no universal right. You don't because you're cannot always access free healthcare. So you do not have access to all hospitals in the Netherlands. So therefore, it's not a universal right as it is in Italy. So therefore, I believe that the Regina case, if I look at the Netherlands, can fairly easily be put aside as an Italian situation, which do not alter the situation in the Netherlands. So we're not too worried about that decision. So then we'll go to the Dôvera case, which in my view is more complex and more interesting. So in the Dôvera case, just to go a little bit back, the Slovak healthcare insurers are not qualified as undertakings. And in this respect, the European Court of Justice sided with the European Commission and overruled the General Court. So that's also interesting that the General Court is being overruled. That also makes it clear that it's not that obvious. There's smart judges, of course, also in the General Court. So if you look at the European Commission and the European Court of Justice, they said that the insurers did not exercise an economic activity despite some really relevant facts, and those are the elements of competition that basically are introduced in the Slovak system. The Slovak Republic changed from a unitary system with a single state-owned healthcare insurer to a pluralistic model in which both public and private bodies can operate, and which is also the case. The insurers must have a legal status of profit-seeking, so they must be profit-seeking joint stock companies under private law, and they can and are allowed to use and distribute profits. The insured have a free choice of insurers, and the insurers can compete in terms of quality and service offered. So basically the value for money. And the General Court said, well, those are elements pursuant to which the nature changes, and the European Court and the European Commission say that that's not the case. And I personally can really follow the reasoning of the General Court. And that's maybe, as Johan said, I'm also a competition lawyer. But I personally believe you cannot have it both ways. You cannot, on the one hand, ask private insurers aiming for profit to compete with public and state-aimed companies that can be unlimited subsidized by the Slovak Republic. Why on earth would you like to do that? Because there's simply no level playing field. So for me, it feels really strange if you're focusing on introducing market forces, introducing competition in the system to make sure that the system starts functioning, so that you have the competition, and the competition makes the functioning of the scheme better. And that's basically what you want. You want better quality for a lower price. That's what you're trying to do. And I do not understand then that you would rule in this case that you say, well, the social aim and the solidarity principle is overarching and therefore bigger, and you need to look at it holistically. But the European Court nevertheless ruled in this way, and they said like that the competitive elements are more secondary of nature, and as pointed out in the sheet, they are only there to ensure the proper functioning of the scheme. So, but if we go back to the Netherlands has a similar system to the Slovak system. It's also a mixture of solidarity, regulation, and competition. And that's also why it becomes interesting, because like both our systems have those elements. So it's not as clear cut if you have a fully solidarity system, but there are regulations, there are competition, and then the question is the mixture, is it going to the one end or to the other? And so is it going to be more solidarity principle based, or is it more a competitive system? For the Netherlands, at least, we have a nice precedent. In 2005, the Dutch healthcare insurers were declared or were qualified as undertakings by the European Commission itself. So it's interesting to look at that decision. So that's the decision of 2005. And there we see, and at that time, at least, the Dutch system has a social aim, basically making sure that everybody is insured and gets proper healthcare in the Netherlands. And it's also based on the principle of solidarity. That's all set by the Commission in its decision. And the elements of solidarity, because there are of course more. That's also what you see on the left side in the slide. There you have something that all have in common. So that's why they all have the green V's. So insurance is compulsory for all citizens. There is a proper prohibition to differentiate premiums dependent on the insured risk. There's a duty to accept everybody applying for an health insurance. And there is a risk equalization scheme, difficult word for a Dutch guy. And furthermore, you see that the Dutch healthcare insurers are private entities. They are allowed to use and distribute profits. And that was deemed, in that case, in 2005, by the European Commission as very crucial. It also says it's one of the most important elements in that case to come to the conclusion that there are undertakings. Healthcare insurers are at liberty to set the level of performance, and they can set out the amount of their premiums. And that's, of course, interesting because that's different in the Slovak case. And there is state supervision in the Netherlands, although it's rather limited, but it's limited and complete, as it's literally stated by the European Commission. And overall, the Commission comes to the conclusion that here the Dutch system and the Dutch healthcare insurers qualify as undertakings, and therefore competition law applies to them. And then, of course, the question comes up, as I already addressed a little bit in the beginning, like, is the Slovak system that different, that the outcome is different, or is the Commission actually changing its mind? More as Mary said, like, do we see two faces in jurisprudence? In this case, I personally believe that the Dutch system is indeed that different. And therefore the Dutch system does not have to fear the Dôvera case, and that it will not alter the view that we currently have. Although there's in both systems, as said, a mixture of solidarity, regulation, and competition, there are some clear differences. And therefore, in my opinion, at least, there are good reasons that the Dutch healthcare insurers qualify as undertakings. And one is maybe it's not a true legal argument, but it's an interesting argument. The first argument is that the first important difference is that the intention of the Netherlands was also to have the Dutch insurers as undertakings, to qualify as undertakings. While in the Slovak case, it's the opposite. They do not want them to qualify as undertakings. It's interesting as a concept, just like to think about this. The second difference is that in the Dutch healthcare insurers can use and distribute profits, and at least as I understand the case, they are less bound to regulations for profit distribution than in the Slovak case. The Dutch healthcare insurers, as a third point, the Dutch healthcare insurers have the freedom to set their premiums, so they can set their premiums themselves. They compete on the premiums, and therefore the Dutch the premiums are not established by law, and neither are they dependent on the income, as was the case in the Slovak Republic. Also, the Dutch system had a risk evaluation scheme. But the European Commission said this leads to an incentive to cut costs, which is not as apparent, at least for me, from the Slovak case. And as a final point, the Netherlands also have state supervision, although it appears that the Slovak state supervision is more severe or more complete than in the Netherlands. So therefore, to sum up, and therefore, if you look on the slide again, like the blue highlights on the right side, the two columns, there you see the differences between, at least in my view, what the difference will be with the Slovak Republic. So therefore, my assessment is that the Casa Regina and the Dôvera judgment may not bring change for the Netherlands, but this might well be the case for other jurisdictions. So I encourage you to do the same assessment for your jurisdictions. But from my point of view, also with the healthcare insurers, which is of course the more interesting case to discuss, the Commission's decision of 2005 still stands. But I fully understand that this could give rise to new arguments. And so new arguments, maybe also to argue otherwise, and that people will bring this up in court. But that's of course something that time can only tell. So I would like to thank you for your attention and give the word back to Mary. Thank you.
Okay, thank you very much, Mark. So just to wrap up quite quickly, thank you to Johan, to Bruno, and to Mark for very eloquently setting out some of the complexities in this area and highlighting some of the ongoing issues. Obviously, the distinction between taxation-funded systems, insurance systems, and the effects that has regarding healthcare providers and purchasers. So in a sense of how it's going, where we are now, we seem to have a sort of continuation by the courts of taking particular lines, defining the limits of where competition, well, the antitrust provisions and the state aid rules are applicable. I think it was Bruno who made the point that actually is applying EU competition policy actually such a bad thing. Certainly that's something we see in connection with some of the responses to COVID-19. So just to wrap up, I just wanted to wrap up by saying that obviously in the 90-minute webinar, we're only starting to scratch the surface in a way. A couple of the other issues which come about. Next slide, please, Ellie. Might be to take a more sort of nuanced approach to the assessment of whether or not an undertaking exists. Johan referenced the idea of focusing on public financing as a means of establishing whether or not we would want to apply the state aid and competition rules, and a test that he devised based on the CPPB judgment about Spanish educational establishments. We discussed this in the context of healthcare in a 2021 article. So this would see, and in a sense, an additional test but one which then starts to set clearer parameters of where competition law would and would not apply. So in addition to the SGEI mechanism, Bruno has also, in his article from last year, spoken about the SGEI exception, and I think I'm correct in saying the implication being that countries may prefer to try and exempt the whole healthcare system from the reach of competition rules rather than engage with the SGEI mechanism. Some of the administrative aspects of that make that a less appealing option, whereas other lawyers have taken the view that actually SGEI could be the way forward when we talk about competition in healthcare. Certainly, one thing we're waiting on at the moment is an evaluation of the state subsidy rules for health and social services of general economic interest, the so-called Almanea package, which extended or sort of facilitated the process of state aid applications in the healthcare context. So it will be interesting to see how that develops. And next slide, please, Ellie. I think it start of 2022, COVID has already been mentioned, of course. It would be remiss of me not to mention it as well. With regard to the state aid rules, the temporary framework relaxing these in the COVID context will soon be coming up to a sort of 2-year anniversary as a temporary mechanism. It was introduced in March 2020. It's been extended at various points since then, now currently extended to run until the middle of this year. The queries this idea of a temporary mechanism. Obviously takes a different approach, relaxing the rules. We're not thinking about SGEI, we're not thinking about this bringing outside the scope of state aid rules, but we're using the exceptions under Article 107.3. And we see this, obviously these are rules which apply across the whole economy, not just the healthcare sector, but affecting the idea of crisis and continuity responses. So crisis in the sense of packages to facilitate access to PPE. But we've seen a couple of cases, more I think relating to continuity, subsidising spas in the Czech Republic, an integral part of public health insurance there, and in the Netherlands, expanding e-health applications to facilitate access to healthcare. So in a paper in 2020, an opinion paper for the European Social Observatory, I suggested what was shaping up as a coexistence of this temporary framework with the wider framework that we've been talking about today, and perhaps there will be scope for learning between the two. I'm going to stick by that point at the moment, for the time being. Another paper on this you might be interested in, if you've not come across it already, is by Biondi and Stefan, where the state aid rules are seen as a sort of almost disruptive mechanism which can help support the development of European Health Union. So again, re-engaging with this idea that the EU and the member state levels are sort of at play here as well. So I say that was very much a sort of whistle-stop tour of some of the issues surrounding EU competition policy in healthcare. And final slide, please, Ellie. Now open to question and answer. So if you have questions for any of the panel or reflections on what we've said, the floor is yours. You can use the raised hand symbol or comments in the chat. And first question to Tammy, please.
Thanks, Mary, and thanks everybody. I really learned a lot this afternoon, and it was extremely useful to get myself a bit more up to date with what's going on here. So I've put my question in the chat because it's quite long. But I'll also say it. So when Jean and I finished our book in 2015, one of the things we tried to do was make sense of not just the competition law case law in the health sector, but also the free movement case law in the health sector. And you said right at the beginning of the webinar that there is an interaction between competition and free movement law that we don't always fully understand, and it sometimes doesn't make sense in terms of doctrine. So the conclusion that Jean and I came to in 2015 was that the court, both the Court of Justice of the European Union and the General Court, use both scope rules and exceptions rules in both the areas of competition law and free movement to manage the interaction of EU law and healthcare provision in the different member states. And what we saw at that time was that there's a continuum which has got health insurance institutions at one end of it, and at the other end of it, it's got things like opticians and dentists. And what we thought was that the way that the court perceived the connection of the health institution with the national health system, whether it was a social insurance system or an NHS type system, affected the level of scrutiny, both in terms of the scope rules and in terms of the exception rules. So at that time, when we'd reviewed all of these cases, we posited that you could put the cases on a continuum, and you would then know whether the court was going to do strict scrutiny, either of scope rule or of exception rule, or light touch scrutiny. So the closer that the court perceived, and it was to do with the court's perception, not to do with an objective standard, but to do with how the court perceived something. If the court perceived that the entity that it was assessing and the compliance of that entity was close to the national health system, irrespective of whether it was an NHS style or a social insurance style, then it would do light touch scrutiny. If the court perceived that the institution or entity was removed from the central core functions of that NHS, the court would do a stricter touch scrutiny. Now, I've been listening this afternoon, and I don't know the answer to this, but maybe I missed it. Does our analysis still stand if we take into account the more recent cases that you guys are talking about?
Johan, do you want to? You're the expert, I think.
I don't know what.
As always.
Thank you very much for the question, Tammy. The analysis is very interesting. Does still stand? I would say that indeed, if I understood correctly, you say if a particular activity is close to the public health system of a particular member state, the court kind of accepts that the competition rules do not apply, so in terms of scope rules. If it's a little bit more remote from the public healthcare system, the court accepts that competition law applies. I think that this is, as far as my understanding goes, this is still true, I would say, for the NHS type of system. I framed it, let's say the public funding is coming directly from the state. Then the court indeed will scrutinize whether a particular entity is very close to the, let's say, to the public heart of the system, like a public hospital, or probably an NHS body, directly operated from the Ministry, Department of Healthcare. Then the court would say, indeed, this is not competition law. We skipped competition rules here. And if the entity is way more remote from it, like a private operator, which is allowed to get some access in the NHS system to provide service because it cannot meet the demand of the consumers, like Bruno said in his country, then the court will tend to say, well, this is something which is subject to competition law. When it shows insurance, I'm a little bit surprised when it comes to competition law, because the court says, well, when it comes to the managing bodies, like for instance in sickness funds, then again the court will assess whether it's close to the public function, and if it's very close to the public function, the public heart of the system, it's not competition law. And healthcare providers, the test is very simple, straightforward. The provision of the healthcare services is for remuneration, and therefore it's economic. So I would say even for public hospitals or state-owned hospitals, but still get their funding, their money from an insurance company, I would say this is a healthcare provider. So I don't think this analysis will provide to the healthcare providers in a social insurance system. As far as my understanding goes right now, as I've now studied all cases, this may change over time if we have new cases. When it comes to free movement law, I think the court has a different approach, because I think that's also what I tried to explain in my article in 2018. What's very striking is that the entire approach of managing bodies, solidarity, is absent in the free movement case law. The free movement case law only looks whether a particular service may be provided on the market, may be provided for economic consideration. And therefore, the strange thing is that, for instance, when UK still was part of the EU, it was very difficult to apply the competition rules to the NHS bodies. But Ms. Watson could leave the United Kingdom and to get treatment in France under the free movement rules. So there are cases where, some cases outside healthcare, where the court, on the one hand, says competition does not apply because of solidarity, and on the other hand, starts to review a particular system under the free movement rules. So I think that when it comes to free movement, it's way more difficult to say a particular system is close to the public heart of healthcare, close to the public heart of a particular social security scheme, and therefore the free movement rules don't apply. I think in that case, the fallback option are indeed the exception rules. So there I think the public heart of a particular system plays an important role. That's the way I view it right now, but probably tomorrow we get a new judgment and I have to rethink everything.
If I may as well, with regard to the cross-referencing between the competition and free movement rules, in my knowledge, I think that the only case, latest case, was Iris case, when the court referenced to the Smiths and Pairborn, if I'm not mistaken. But to the second and the main question, in my opinion, in line with the latest the Casa Regina judgment, opticians and dentists would be also covered within the non-economic nature of the services, because as I observed it, that these institutions which are financing the health services are consuming also providers, so that for providers refer the same rules as for financiers. So basically, if they are part of this system, this public system, which is governed by the principle of universality, solidarity, social aim, etc., then also dentists and opticians and whoever is part of the non-economic services, which is in my opinion a bit strange, because majority of those entities are for-profit entities, which goes against the functional approach and definition of economic and non-economic nature, and brings us back to the institutional definition, which means that public entities would be public providers would be not be undertakings, and private providers would be undertakings, which sounds a bit strange to me. I don't know what do you think about it?
Do you want me to respond to that, Mary?
Yes, that's fine. Go ahead.
So thank you both for your answers. So I mean, I was thinking a lot about what you were saying, Bruno, but I think it's to do with how the court perceives the organization of that particular member state's health system. So the court perceives that that particular member state has decided to bring everything, opticians, dentists, everything, all within its public function. And then it doesn't do this. It does a light touch scrutiny, or it does a light touch application of the scope rules wherever it does it. Whereas in a system like the Netherlands, or other ones, the court perceives that some institutions that are providing some healthcare services are more remote from the publicly funded system. I mean, it's super difficult to find consistent doctrine. But part of the reason that it's super difficult to find consistent doctrine is because there is so much divergence between the different health systems. So we would need literally thousands of cases in order to get consistent doctrine. And of course, we don't have literally thousands of cases at the EU level. We do
million of member states.
Well, maybe, yeah. But we do have hundreds of cases if you look at the domestic level ones, of course. And this is where the work that you guys do at the domestic level is really, really important. But yeah, thank you for that. I mean, I do agree with you, Johan, that the scope rules are applied completely differently with free movement than they are with competition. But I think the exemption rules fit my model. So it's lighter touch proportionality if the court thinks this is actually a public, this is part of the core provision of health services. What I'm not sure is what's going to happen when the COVID cases work their way through, because a ton of the COVID cases are about things that really are in many systems remote to the center, because they're about buying things on the open market, like PPE tests or whatever. So when the court has got, I think something like Koen Lennertz was saying in a webinar the other day, the court has already got something like a dozen COVID cases in various different areas in front of it. Some of them are not relevant to the discussion today, because they are things like, did the EMA take the correct decision when it authorized a particular vaccine or whatever? But many of them will be relevant to this conversation. And I wonder whether the COVID pandemic actually will change the way the court thinks about health systems and how they integrate with the internal market or free competition within the EU. And that's something that we all will want to watch over the next 5 years or something. Anyway, thank you so much for your answers. Much appreciated.
Mary, I unfortunately have a hard stop, but I already need to be another call for a minute. So it was a pleasure being here and speaking to you all. And
thank you very much, Mark.
Catch soon.
Bye-bye.
Ciao, everybody.
Bye. Thank you, Tammy, for that question as well. We're nearly out of time. Can I just ask if there's any other last questions or comments? Obviously, we'd be very happy to follow up outside of this call as well. If not, then I'd just like to say thank you again to Mark, who's just left, but also to Johan and to Bruno as well. And thank you to our audience for joining us today. We'll be able to follow up with the recording of today's session. We'll be stopping the recording in a minute. That will go up on the EU HealthGov website along with a write-up of today's. But if you're not